Good afternoon, everybody, and thanks, Steve. I'm not quite sure what Steve knows that I don't, but I may find out later. Continuing with the seminar's overall theme of Guernsey International and Interconnected, this afternoon Mark and I would like to talk to you about a range of topics which fall under three variations of that main theme. Firstly, international, secondly, international and interconnected, and finally, interconnected. What do I mean by all of that? Well, just if I could run through the agenda very quickly. I'm going to be starting off with purely international matters, focusing, unsurprisingly, on AIFMD and MiFID II, and also answering the question, where is Louise? Louise is conspicuous by her absence from the stage today, but more on where she is and what she's up to later. But I would say any rumours suggesting that Louise is not here because she's camera shy or she's yet to register her image rights are not true. I am then going to move on to international and interconnected, talking about our involvement on international committees and the value it brings to the jurisdiction and how we as a smaller jurisdiction can play a part on the global stage. Finally, Mark will cover our interconnectedness from a domestic angle. That's being interconnected with our colleagues across the Commission, with government, other local agencies, and most importantly, with you in the industry. Just to expand on that slightly, the investment slot today has been sandwiched, and I'm conscious, having said that term, it's probably not the best one when you're all starting to feel a bit peckish around about now, but we've been sandwiched between the Conduct Unit and the Fiduciary and Innovations Division for good reason. Mark will illustrate our interconnectedness, particularly with our colleagues in those divisions, by commenting briefly on the implementation of the Guernsey Financial Advice Standards and by describing some of the proposals we've seen in the innovation sphere and how we've been working with Fiduciary and Innovations in our consideration of those proposals. But he will start up by picking up on some of the changes proposed to the Protection of Investors Law under the Revision of Laws project, as detailed in the recently issued discussion paper. Mark and I are intending that should all take about 30 minutes, leaving us with roughly 10 minutes or so, when we'll be very happy to take any questions you may have. Nick Herquin, one of my assistant directors, is with us on stage to help answer any questions on AIFMD or any other questions that you might wish to direct to him rather than at me. But I will get started. Before I get started with the main thread of my talk this afternoon, I wanted just to take a couple of minutes to reflect briefly on the fact that this is the 5th year the Commission has run this seminar. Over the years, we've received feedback in the investment division that we're too funds-focused in our presentation. But when I was running through our speaking notes for today, it occurred to me that it's not actually been necessary to make sure that that balance is there this year, as the distinction between the funds sector and the asset managers and investment managers is becoming ever more blurred. Many of the topics we'll speak to today touch on both sectors. For example, MiFID II crosses over into both sectors, and innovative proposals could be structured as funds, or as we have seen more often than not, as non-fund structures. I hope you will agree with this, but if you do not, I'm sure that despite there not being any official feedback forms this year, you will still let us know. And we would welcome it. After all, feedback is a gift. So, moving to my first topic of international, and to kick off with, as you'd expect, AIFMD. So what's the current position? Since its implementation in July 2013, Guernsey has been operating under the national private placement regimes largely without significant difficulty. The Commission has provided attestations to EU competent authorities, aiming to ensure that the applications by Guernsey funds progress as smoothly as possible. We've continued to have dialogue with our EU counterparts, seeking to influence their view of Guernsey funds. To that end, you may have seen from our website in September, we were able to reach agreement with the competent authority of the Netherlands, the AMF, for them to accept an overarching statement from the Commission for applications, meaning individual attestations would no longer be required. The AMF still requires confirmation that Guernsey AIMs are appropriately licensed by the Commission, but the AMF has confirmed that merely a screen print from our website would satisfy their requirements. In addition, we've also consulted on the guidance for depositories under Article 36, and the guidance, together with the feedback statement, was published on our website on the 17th of November. However, for AIFMD, the next steps are far more important than probably the current position, the main one being passporting. ESMA is now reviewing the AIFMD National Private Placement and Passport regime. ESMA is required to issue its report, including advice on whether the passporting regime should be extended to third countries, to the European Commission by July 2015. Now, some commentators are suggesting that ESMA might decide to defer issuing any advice or request an extended time frame to its deadline. However, in our discussions with ESMA, they've indicated they're confident in completing their report on time. Indeed, ESMA issued on the 7th of November a call for evidence paper to gather input on the key issues that would determine the orientation of their opinion. We will be responding as a Commission, however, it will form part of a wider response to a direct request from ESMA for the Commission to provide information not only on our experience to date on the national private placement regimes and the approaches adopted by the EU member states, but also a description and explanation of how the fund management model operates in the bailiwick. The call for evidence paper is aimed at non-EU fund managers and advisors and their representatives, thus encompassing all relevant parties in the fund sector. And we would encourage as many of you as possible to respond to ensure our perspective is heard. The deadline for responses is the 8th of January 2015. And if when you come to respond you've got any questions about the call for evidence paper, please do contact me or Nick, or indeed you're welcome to ask us here today. Having covered AFMD, I will now turn to MiFID II and what's the current position there, which brings me back to my earlier question of where is Louise today. Louise is actually in Brussels today attending a meeting arranged by SIBO at the EU Commission. The main purpose of the meeting is to discuss a bifurcated regime in respect of equivalence under MiFID II. It's the view of the working group on MiFID II that a form of bifurcation would be the jurisdiction's preferred response to equivalence under MiFID II. SIBO have stated that the EU Commission is unlikely to accept partial implementation, but may be receptive to a rulebook with MiFID-compliant chapters. This proposal for a bifurcated regime, together with a wider overview, was proposed to industry at a town hall we held on MiFID II in September, which many of you will have attended. Whilst Louise and the Investment Division are coordinating the jurisdiction's response to MiFID II, it reaches wider than the investment world, but we're still not entirely certain to what extent. I'm hoping, therefore, in the audience today there will also be representatives from the fiduciary sector, again, hence the reason for the running order. Or, at the very least, if you're not responsible for the fiduciary activities in your organisation, I would ask you to encourage your colleagues to watch this seminar once it's available on our website, together with referring to the overview of MiFID II and the FAQs on our website. Now, apologies to those of you that attended the town hall, as you'll have seen the next couple of slides before, and I'm conscious that both slides are quite busy. But even if you can't take in all of the detail now, they're very useful takeaways, and they will be available on our website in the not too distant future. Or indeed, some of you may be aware and are planning to attend Louise's forthcoming presentation at the CISI lunchtime seminar on the 16th of December, where again she will be talking about MiFID II. And you will have there, I'm sure, another opportunity to look at these slides more closely. Essentially, they're a timeline for MiFID II. In 2014, we are now at the top of the slide in the box November 2014 with the red text. All of the left-hand side of the slide has already happened. The red text symbolises the work that's happening domestically with the revision of laws, which Mark will touch on later. But picking up on the overall theme of this seminar, it is a great example of international and interconnectedness in practice. We're having to ensure as far as possible that our domestic changes are future-proofed to allow us flexibility around MiFID II. The bottom right-hand box refers to the ESMA public consultation to be published on the regulatory technical standards and implementing standards, and we will keep you alerted to its publication. The timeframe moves on through 2015, 2016, and finally January 2017 when MiFID II will apply. So within that timeframe, what steps are we taking and what next steps do we propose? Well, I've just referred to the consultation paper from ESMA, and we will be reviewing that once published. But in the meantime, as well as the meeting Louise is attending today, she met together with colleagues from Jersey, officials from ESMA in early October. This meeting covered a number of topics, including a discussion on MiFID II, with the islands advising they were especially interested in third country equivalence. It was noted that the islands need to do further work on explaining the business model. That is, how we can assist Europe in its capital raising objective, in particular in raising funds from outside Europe for investment into Europe. And this is something my team has already started to work on. We are taking every opportunity to interact with counterparts in the EU authorities to discuss implementation of MiFID II. Another step is that Louise and I are due to meet with Stephen Hanks of the Markets Division at the FCA early next year to discuss MiFID II implementation and the FCA's position on the significant issue of branches for retail investors. Our aim with all of this interaction is to get noticed, but without making a nuisance of ourselves, to proffer ourselves as friendly, cooperative, geographical neighbours. Work on MiFID II will not be done in isolation by us, and we will continue to have interaction with government and industry through the means of the Working Party. But just to reiterate, why is my team devoting so much time and resource to MiFID II and AFMD? One, in short, market access. Far from being business prevention officers, we are in fact endeavouring to ensure that the EU market, and yes, I know you've heard it before, but that includes the UK, remains as open as possible for Guernsey funds and financial service providers. Whilst we do not have a definitive figure, a good estimate is between 60 to 80% of our business and investment relies on the EU. This is why it's essential that we take the measures needed to ensure we retain our market access. But we must also remember AFMD and MiFID provide opportunities, and we should explore all of those as well as seeking to address the challenges. Moving to my next topic, which I described as international and interconnected. When Louise isn't in Paris or Brussels talking to ESMA or the EU about MiFID or AFMD, she's more often than not attending the IOSCO Standing Committee 4 on enforcement and the exchange of information. Standing Committee 4 considers and reflects upon what is probably the most significant piece of international cooperation work that IOSCO undertakes. Experiences of enforcement cases are shared and improvements to the mechanisms for the exchange of information discussed. Earlier this year, we were also invited to sit on the MMOU screening group. The MMO screening group does exactly what it says on the tin and screens the applications from those jurisdictions which are not yet signatories to the IOSCO Multilateral Memorandum of Understanding. The MMOU represents a common understanding amongst its signatories of how they should consult, cooperate and exchange information for the purpose of regulatory enforcement regarding securities markets. Given her experience in obtaining the Commission's own signature to the MMOU and her wider international experience, Louise was the obvious choice to represent us. Both Standing Committee 4 and the Screening Group are chaired by the FCA, making it a good opportunity to further build our relationship with them, as well as the other 26 regulators which make up the Screening Group. But why is it important for us to be involved, and what value as a smaller jurisdiction do we bring to such committees? Can we actually really influence matters? Well, the main advantage we have is we are not only high-level policy people, we are still close enough to the ground. As well as being involved in policy, Louise is still a supervisor, and while she doesn't actually perform site visits, though we can't actually ever rule anything out when we're flexing our resources, she does review the site visits performed by others in my team. We add value, therefore, by being able to comment on the practical application of policy decisions. The other advantage is, as William said yesterday, if we contribute, we are more likely to be listened to. And from the list of jurisdictions involved in the Screening Group and Standing Committee, you can probably identify a few with whom a better dialogue can only be a positive thing. It's an opportunity to inform, engage, and hopefully educate our neighbours in the EU and counterparts globally about our financial services business, who we are and what we do, ultimately trying to dispel misconceptions about our jurisdiction. The IOSCO annual meeting provides for another opportunity for international interconnectedness. I attended the IOSCO annual meeting in late September, held this year in Rio. Now, I know what you're all thinking, Rio, hard life and all that, but as many of you will know from your own experiences, business travel is never as glamorous as it may sound. This photo, and apologies, it is a bit hard to make out, despite our shared surname, David Bailey is definitely no relation, but that pink blob is an umbrella and not my finger in front of the lens, and it was actually the view from my hotel room window. I thought at least I might get a nice view in the morning before I had to disappear down into the windowless basement of a corporate hotel, but sadly no. Anyway, the IOSCO annual meeting is worthwhile for many of the same reasons as I've outlined for the Standing Committee 4. The being seen, the networking, talking to counterparts in meetings but also in the margins, and continuing to explain the financial services we provide in the jurisdiction. Often others help us with promoting our image. For example, at this year's annual meeting, Mary Jo White, chair of the United States Securities Exchange Commission, publicly thanked Guernsey, amongst a handful of other jurisdictions, for its assistance in an enforcement case it had successfully brought against a brokerage firm. This slide shows the actual extract from the SEC's press release on that case. And then even more recently, another press release was issued in which we were thanked again for the assistance we had provided. Whilst it is the Commission that is specifically being thanked, and largely due to the efforts of my colleague Kevin Bown, it is actually a jurisdictional response in these cases. The Commission is only able to assist other jurisdictions on these types of cases as a result of the good work that our licensees undertake. Now, the remainder of this slide covers other events we attend: IOSCO European Regional Committee meetings, the enlarged contact group of collective investment scheme supervisors, and regulatory seminars, none of which I intend to go into too much detail here. Just to reiterate, though, the networking opportunities at these events are vital, not because we're looking for opportunities to develop our careers in warmer climes, but because it can bring about positive changes for us as a jurisdiction. The case of the new arrangements around the attestation with the Netherlands AMF, which I mentioned earlier, was made possible as a result of the networking that Nick did at the Enlarged Contact Group in 2013. And at his suggestion was followed up by Louise at the same conference in 2014, resulting in the agreement we have now. And on that note, before I hand over to Mark to talk about being interconnected in the domestic sense, I would just like to take this opportunity to thank my team for their support and hard work over the past few months and for their commitment to the Commission and indeed Guernsey. I'll now hand over to Mark, who will describe what else is occupying us and keeping us busy when we're actually in the jurisdiction. Thank you.
Good afternoon, everyone. It's good to see so many of you here. Guernsey International and Interconnected. Well, Stephen Cole said at the start of it, and first I should say, Emma, please stay. and I'm also the Deputy Director and hope to be Deputy Director for some time, not some temporary time. But Stephen also said that today this event is being filmed. Now, in order that more of you were able to come here, we have been live streaming this event down back home at the Guernsey Financial Services Commission. And let me tell you from personal experience of yesterday, it is a lot more fun watching it down there than up here. There are several reasons for that. Reason one is that one can leave whenever one wants to without causing offence. Reason two is that were I to move more to the left than what I currently am standing now, actually some metaphysical type experience would be experienced by my colleagues back home, in that they would hear my voice, but at best they would see my right hand and probably not see me at all. So at one stage yesterday afternoon, we were playing a little game of Where's Wally, wondering when a person would reappear and at what part on the screen next. Option three, and I dedicate this one particularly to our chairman because I know how fond our chairman is of music. On occasions, particularly later on in the day when the school children were getting back home, clearly the broadband was getting busier and busier, and therefore there were a little bit more streaming buffering problems. And what that meant in practice was that some of it sounded a bit closer to a rap. Last time I spoke at this presentation, indeed like the story I've just said now, I told another true story which actually I enjoyed even telling far more than the one I've just said to you, which is how when I was walking up to St James, and typically for me I was, to say the least, running short of time, and by running short of time I mean that I was running short of being 5 minutes late, I heard two men in front of me make the following comment: "Another day of the Commission telling us what to do." I thought that was far too good a story to use, and so I did, and that departure from script did in fact lead to some white faces amongst my colleagues wondering where on earth I was going with that particular story. But I went on to say that I hoped that the day would be one of engagement and discussion. And certainly I hope to show over the course of the next few minutes that this last year for this division has very much followed our Commission's line of listening and engaging with you. We haven't compromised our sound regulatory judgment, I hope, but if anything, being interconnected must surely mean listening. The revision of laws, well, this revitalised project has seen unprecedented consultation with industry. There have been working parties, project boards, internal working parties, discussion papers, a future consultation paper in the offering, open houses, drop-in sessions, fireside chats, and in fact at one stage I half expected Barack Obama to come up with a State of the Union address. We have done all this to ensure that we are working with you towards a common goal of a workable framework of regulation with no unintended consequences. And I have to say, sitting on the working party, it really has felt like no stone has been left unturned. And I certainly agree with the chairman's comments that he made yesterday. It has been a much better start this time round to this project. And I hope, with the paper that is out there for you to look at, I hope you would agree. Excuse me. From the perspective of this division, our work has largely focused on the ability to have a flexible regulatory framework, or as we have been calling it, and indeed this name has made it into the paper, future-proofing. We believe, for instance, that some matters should be dropped down from the law into regulation. This does not necessarily mean us finding ways to regulate you more, believe it or not, but it will give both the Policy Council and us the opportunity to respond quickly to any unexpected threats, zooming over the horizon, or indeed sudden opportunities, and I'll talk a bit more about that later. In addition, we are considering how flexible fund products need to be in the future, and we are working with GIFA in that respect. Considerations on the table include a very private fund and a private placement fund taking various initiatives and influence from AIFMD. Also, we are not ignoring whether or not Guernsey should try and have a future in the retail fund space. There are a couple other highlights I would want to bring to the revision of laws piece, but please do respond as the paper asks you to do. One is an initiative that indeed came from one of the open house forums we had, which was whether or not there is the opportunity for you to come to us. I have to say, it would be for a fee, but for us to make a declaration whether a particular product is a fund or not a fund, the feeling out there was that to have that option, which would be a permissive option, you would not have to use it, but it's there if you would like to use it, would just give that bit more certainty around some of the areas where currently there are very grey areas around some of the products that Guernsey PLC is involved with. Secondly, we've opened up again the issue of prime brokerage and whether or not there does need to be a designated custodian in the island for open-ended schemes. That, of course, is a work stream that started many years ago with the flexible policy on hedge funds. But third, and as all my internal colleagues would tell you, is something very close to my heart, is a clear distinction between when we are engaging with you as supervisors, providing sensible, robust discussion, providing solutions within those robust discussions, and the difference between that and enforcement, where if any of you were at Mr. Godion's speech yesterday, I understand enforcement were referred to as shadow warriors. We are not shadow warriors, but we are more than happy to talk and have robust discussion within the supervisory piece. So turning to innovation, it seems that no presentation would be complete these days without referring to fintech and innovation. And certainly this has presented a large part of my workload over the last quarter. In fact, at one stage I thought I was actually in a different job to the one that I'd applied for. You may well have seen the press release regarding the rebranding of my colleagues in the Fiduciary Supervision Policy and Innovation Division under the leadership of Gillian Browning. The press release went on to explain that Philip Marr, as the Commission's economist, will also be available to discuss early-stage innovation ideas. Whilst Gillian and her division will be the first point of contact for innovations, and of course are very much spearing the consideration of forthcoming fintech legislation, and I will let Gillian speak more about that, there are still proposals which directly involve funds or are clearly investment related, and where that happens, this division will still be included in those discussions. I'm pleased to say that communication between the two divisions is strong, and I can assure you that you would receive one joined-up response from these two divisions, and we have put in place controls to ensure that that will happen. We are one commission, and we're endeavouring to enforce that. So what areas in innovation have we been looking at? Well, particularly from the investment side, crowdfunding and peer-to-peer lending. That will come as no surprise to you, I'm sure, and we have had several meetings involved in this space. We're continuing to look to the Policy Council for guidance on any legislative changes required in order to appropriately regulate such offerings, and the feedback we are getting is that many of these individuals coming to the jurisdiction see greater traction in being regulated. Peer-to-peer lending in particular requires careful thought over the legislation, and going back to what I said about the revision of laws, we are very conscious that we must avoid unintended consequences. Not least, the last thing we want to do is to capture within that other forms of debt. Purer crowdfunding, where a site domiciled in Guernsey is being used to arrange investment, would clearly fall as a restricted activity under the POI law as it currently exists. Nevertheless, there will still be challenges, not least over whether that product or service is actually domiciled in Guernsey. And as those of you who are tax experts will know, and thankfully I'm not one, is that this is a point that our friends at the G20 and OECD have been considering right up to the present day. You may also have seen certain comment on the web about how we, the Commission, are entering into the world of online gambling. There's much I could say about this, including how, thanks to the due diligence I did, I could now recommend to you the best sites to use for such events. However, let me limit this to commenting that spread bets currently fall within the definition of contracts for difference under the Protection of Investors Law. I mention this because sports spread betting is one subject which we do not believe we, the Commission, should be regulating, and we are currently exploring what we can do about that so it stays solely in the field of the AGCC. So, believe it or not, what I said before was actually true. Future-proofing proposals to the revision of laws would enable us on occasions to regulate less and not more. So how will our applications process change in this new world of fintech and innovations? Well, as with any new application, our focus will still be on the fitness and propriety of the individuals involved, and we will be seeking to understand the product and the structure, the business model, if you like, being utilised, and the risks attached to that model. We have to consider how firms will consider onboarding, client suitability, or the current buzzword now is appropriateness, anti-money laundering, and promotional statements that should contain responsible risk warnings. We also have to consider whether the target market is institutional retail, that is B2B or BTC in the ever-increasing jargon. So in that regard, I repeat, we are very open to exploring new ideas with industry, and our approach to date has been to meet with firms with no preconceptions. This particularly came home to me after one meeting when I commented to colleagues that it is very rare for me to be in a meeting where the visitor is more scruffily dressed than me. To quote John Maynard Keynes, and I dedicate this quote also to the chairman after his speech yesterday, "The world has not yet changed, but we are dancing to a different tune." Having got married last year, my wife will be the first one to tell you I'm not the best dancer. Nevertheless, in this field, I'm doing my best. And we have had to consider very carefully the paradigm of fitness and propriety in this new tune of fintech. Where a firm requires a license, we still have to reference Schedule 4 to the POI law, of course we do. But there is no doubt that track record in this field is very different, and we will interpret it on a case-by-case and appropriate basis. I cannot say enough, this is a rapidly changing field, and like those of you who have already been engaging in this field as well, we are learning. We ran a session for advocates in October. There are likely to be many, many more such sessions. In any case, our door is open. Please come and see us with proposals, and let us see if we can make things work. Those of you who have just heard Rosemary speak, and those of you who have been following our website, will be well aware that as at 1st of January 2015, some of the hard-earned work colleagues and I did some years ago on the conduct of business rules then will be confined to the dustbin of history. That's always slightly painful when you've put a lot of time into something yourself. And the new conduct of business rules, which are compliant for GFAS, will be in place. As Rosemary said, this has been the result of several consultations, feedbacks. I think it's been 2 consultations, 2 feedbacks, and there's been considerable hard work from Rosemary and indeed Louise Bugle and many others. Here again, I would suggest has been an example of us listening to legitimate concerns. Originally, we were going to put a condition on each licence, and that condition would depend on the type of client being advised. You, quite rightly, came back to us and said that a connotation of a condition would always be somewhat pejorative. We have listened to that, and we have added more scope and more substance to the rules that are coming in place, such that a condition will not be required, and I hope that does meet with your favour. We have listened to representations that the definition of client's attitude to investment risk needs to be expanded, and we have done that. Further, we have listened, as Rosemary has already said, to other representations, and although we have not acted on them yet, we have carried them forward into the MiFID II and revision of laws work streams. Finally, in the last week or so, several of you have asked us for a version of the rules black-lined to the 2009 rules, and my colleagues in conduct are currently working on that. Having tried to do black-line documents on other rules that I've been involved with, I can only offer my colleagues my sincere condolences and the very best of luck in achieving that document. Finally, understandably, many of you are still somewhat curious about the latest 5-letter acronym on the block, PRISM. Well, we went live on the PRISM IT architecture in the summer of this year. However, to all intents and purposes, the methodology of PRISM had been incorporated into our supervision of significant firms over the course of this entire year. So it is an opportune time for me to make some observations on what PRISM has meant for us, and I hope you find them useful. As the chairman stated yesterday, it has certainly made us leaner and meaner, more focused on the risks, and more able to react quickly as those risks present them to us. We have always been strong on prudential risk, conduct of business risk, and corporate governance. But to that we have added several areas, most notably business model analysis. PRISM as a whole has enabled us to better identify an appropriate level of supervisory engagement to your business, and staff are empowered to take appropriate supervisory decisions. The assurance of this process comes through the risk governance panels, or RGPs. These are populated with senior officers across the Commission who challenge the staff responsible for supervising a firm. Let me tell you from personal experience of one only last week, such challenge is certainly no picnic, although as many of you know, I always enjoy a good, robust debate. So at the start of this year, we restructured our division to reflect the PRISM way of working. We have a low impact team, which also deals with applications, a medium high team, and a third team covering high and medium low. Now, in discussions I've had, I think there probably is still a little confusion out there as to what these categorizations mean. If you are categorized medium high, it does not mean that you have a medium high risk of failure. The categorization of risk is separate to that of impact. What that medium high impact metric means is that you have a medium-high impact on the bailiwick. It is exactly what it says, and there's no further disguise to that. So this year, over 2014, in accordance with the consideration of those impact levels, our main focus on the visits we have undertaken to you have been on high and medium-high impact firms. So far, we have found the PRISM approach to have given us a far better understanding of your business, and I would hope that we have demonstrated a better appreciation of your business in the discussions we have had with you than perhaps what we have in the past. I think it is fair to say that from us, you will see less tick box and more talent. So in conclusion, I hope you would agree that we have listened to you where we can, whilst remaining true to sound supervisory standards often brought on us through international pressure. And in that spirit, may I thank you all for in turn today listening to me.